All right, good morning, everybody. Welcome on this, if you're in Houston, this beautiful liquid sunshine morning. Hope you're safe and hunkering down. My name is Eric Tonsul. Thank you for joining us today. We're going to be discussing the Texas Property Code. This is 201. Cliff Davis presented 101 last week, I believe. So now we're going to get down a little bit deeper, drill down a little deeper with the 201 provision, or 201 form of this webinar. Kyle, they're asking we could turn up the volume. I don't know if
you may have to speak up a little, Eric, or it may be on their end that they need to turn up their speakers on their computer, because I hear you just fine.
Okay. Forgive me, whoever asked that question, if you could. All right. Valentina says she can hear me just fine. So it may be a speaker issue on your end, whoever submitted that request. Okay, quick disclaimer. The information presented today is based on the laws that exist as of January 24th, 2023. The information presented is for educational purposes and does not constitute legal advice. If you need legal advice relating to any of today's topics, please consult your attorney. Next slide, please, Kyle. So this is what Cliff discussed last week was the basics of the property code, open records, open meetings, amendments, and hearings. And what we're going to discuss today, next slide, please, Kyle, are collections and foreclosures, the standard of care for directors, attorney's fees, and statutes applying to both condo and single family associations. So before we go further, at the top of the screen, you see the blue that where it says discussion points. If it says HOA on one of the slides going forward, that's referring to single family townhome associations that are subject to chapter 209 of the property code. And if it says condo, then it's obviously a condominium slide. And there will be some slides at the end of towards the end of the presentation that pertain to both single family and to condominium. So you'll see that at the top of the slides. All right, next slide, please, Kyle. All right, so first of all, let's talk about the standard of care for a single family and townhouse associations and for Chapter 81 condominiums. The duty of care for a director is a ordinary standard of care, which is operating in good faith with just a regular standard of care versus a fiduciary standard, which is if you have ordinary care here, fiduciary is way up here. It's much higher. It's a much stricter standard. And that applies specifically to Chapter 82 condominiums. Just so we're clear, a Chapter 82 condominium is that's Chapter 82 is also known as TUCA, which stands for the Texas Uniform Condominium Act. That applies to condominiums where the declaration was recorded after January 1, 1994. For any condominiums where the declaration was recorded prior to January 1, 1994, Chapter 81 applies to those condominiums. And there are some provisions in Chapter 82 that also apply to Chapter 81. If you look at Chapter 82 in your property code, one of the first sections is titled applicability, and that will tell you which sections in Chapter 82 are applicable to Chapter 81 condominiums. So again, back to the standard of care, Chapter 82 condos have a fiduciary standard of care, or they have fiduciary duty to the association. Unless you're an 81 condo and it specifically says, or a single family association, and your governing documents specifically say that the directors have a fiduciary duty, then that changes things. But if there's no reference to the standard of care, then what you see in your slide is what applies. Next slide, please, Kyle. So this is the general standard is set forth in the Business Organizations Code, which is a code here in Texas. Much like the Property Code, you have the Business Organizations Code. Chapter 22 is a Nonprofit Corporation Act portion of that code. Chapter 22.221 sets forth the general standards for directors. And it says directors are not liable for actions if the actions are taken in good faith with ordinary care and in a manner that the director reasonably believed to be in the best interest of the association. So that is your standard for, or your elements for a general ordinary standard of care that we referenced earlier. Next slide, please, Kyle. So TUCA again, as I mentioned, the Texas Uniform Condominium Act imposes on an officer or a member of the board a fiduciary as a fiduciary of the unit owners or for such officers or board members' acts or omissions. 82103 is applicable to condos after, that's what I referenced earlier. That's what tells you the applicability of the provisions in TUCA that are applicable to Chapter 81 condominiums. Next slide. Talking about attorney's fees, Section 5.06 of the Property Code references the ability for an association to seek the recovery of its attorney's fees. So 5.06, forgive me, I'm going to read this because this is right out of the statute. It says, in an action based on a breach of a restrictive covenant pertaining to real property, the court shall allow to a prevailing party who asserted the action reasonable attorney's fees in addition to the party's costs and claims. And then what you see there are the elements for determining reasonable attorney's fees. Now, I want to bring or show particular attention to the red words in this slide because it's very important. I'll give you a hypothetical here. Let's say that you're an association pursuing a deed restriction violation against an owner. So the violation is obviously a breach of the declaration or most likely the declaration, possibly the rules and regs, whatever the case may be. And so the association brings the action and prevails in the lawsuit against the owner. In that hypothetical, the association has the ability not only to seek the injunctive relief that it's most likely seeking, but also the recovery of its attorney's fees, any civil damages if you're seeking civil damages, and court costs and interest. Interest is applicable. Now, same hypothetical, except the owner prevails in the lawsuit and wins in the lawsuit. Now, a lot of times you have owners say, or their attorneys that aren't particularly familiar with property owners association law say, well, we want to seek the recovery of our attorney's fees. Well, no, it doesn't work that way because, again, looking at that red language, the party that asserted the action and prevails. In that hypothetical, the association filed the lawsuit against the owner. The owner did not file any kind of counterclaim or any other claim against the association. So it was one-way street, association pursuing the owner. Association wins, prevails in the lawsuit, gets a judgment. So now only the association is able to seek to recover those fees. If the owner prevails, they did not bring the action, so they're not entitled to seek the recovery of their attorney's fees from the court. Next slide. So for condos, this is for all condos, 82161. Again, I'm going to read this, forgive me. If a declarant or any other person subject to this chapter violates this chapter, the declaration, or the bylaws, any person or class of persons adversely affected by the violation has a claim for appropriate relief. So again, what that says basically is anybody has the right to sue somebody else for a violation of the declaration or the bylaws. So it's not just the association that only has standing to bring the action. If somebody's in violation, another owner has standing to bring that same action. When I say bring that action, I mean file a lawsuit against the offending owner. The prevailing party in an action to enforce the declaration, bylaws, or rules is entitled to reasonable attorney's fees and cost of litigation from the non-prevailing party. Next slide. And then in 209.08 of the Property Code, again, this is only for single family and for townhomes subject to 209. The association may collect the reimbursement of attorney's fees and other reasonable costs relating to collecting the amounts, including damages to the association for enforcing the restrictions of the bylaws, the rules of the association, but only if the owner has provided a written notice that the attorney's fees and costs will be charged to the owner if the delinquency or violation continues after a date certain. So again, this is where the importance of that 209 letter comes into play. That's why it's very important that the 209 complies with the requirements in Chapter 209 of the Property Code, because if you do not, then that could very well jeopardize the association's ability to seek the recovery of its attorney's fees. So, we oftentimes get a little bit of pushback because we're kind of sticklers for your 209 letters to make sure they comply with the Property Code. Again, if they do not, it could get really ugly. I mean, this could be something that an owner's attorney brings up almost like during trial. And if that's the case, you may not be able to recover any of your attorney's fees up to that point. So that's why it is so important that your 209 letters comply with 209.06 or 209.006 for the Property Code. And again, whenever an account is turned over to our office, That's one of the first things we do on our end is we check the 209 letter to make sure that it complies with the property code. If it does not, we will send a email or communicate with you to let you know that the letter does not comply and why, and then discuss the association's options going forward. Next slide. So again, we're still in 209.08, an owner is not liable for attorney's fees incurred by the association if the fees are incurred before the conclusion of the hearing. If a hearing is required, no hearing is required if you're filing a TRO or foreclosure action. So what that means, if we're filing a lawsuit seeking a temporary restraining order, that's what TRO stands for, temporary restraining order. If we file a lawsuit seeking a TRO, those are the types of lawsuits where time's of the essence. Somebody is building a home, for example, hasn't been approved. They're going gangbusters. They're clearing the lot. They're knocking down trees. They're getting ready to putting down the forms, pour concrete. We got to get that TRO ASAP. And so it doesn't make any sense to send a 209 letter, which gives an owner 30 days to correct the violation or request a hearing. 30 days, you could have a substantial amount of that home constructed in my hypothetical. So that's why that notice is not required if you're filing. It's actually a suit seeking temporary injunctive relief or a foreclosure action. Also, if the owner does not request a hearing under that section before the day by which the owner must request a hearing. So again, if it's not a TRO scenario, it's just a regular deed restriction violation, you send the 209 letter. Again, the letter gives the owner, for a DRV 209 letter, gives the owner 30 days to correct the violation or request a hearing. You have to wait for that 30 days to come and go. And if they request a hearing, then you have to have that hearing. If they don't request a hearing, you have to wait for the time period to request a hearing to expire, and then you can go forward, and then you can seek the recovery of your attorney's fees. Next slide, please, Kyle. Okay, no legal fees without prior notice. Again, this is what I just explained basically before. An HOA may file a suit against an owner other than a suit to collect the assessments or foreclose an association's lien or seek a TRO or TI. TI stands for temporary injunction. The association or its agent must give written notice to the owner by certified mail, return receipt requested, and the 209 must be sent to the owner prior to reporting a delinquency to a reporting service. That's a new wrinkle that was added at the last legislative session, that reporting service, basically a credit bureau. And so I'm seeing a lot of questions pop up. I forgot to mention this at the beginning, my apologies. I will take questions at the end of the presentation. If I start answering questions during the middle of it, I'll never get through this thing. So please put your questions in the chat. Once I get to the end of this, I will, address all this, as many questions as I can within the time allotted. Next slide, please, Kyle. Okay, there's limitations of foreclosure. This is for 209 associations, not condominiums. It prohibits foreclosing solely for records costs, fines, or attorney's fees relating to the collection of fines. So, in other words, an association cannot foreclose on a property if the amount owed to the association consists solely of fines or attorney's fees relating to the collection of those fines, or on the slide you see records costs. What that is if an owner submits a written records request to the association to inspect or obtain copies of the association's books and records, depending on your open records policy, you may be able to collect the cost. It sounds like a tornado outside. My apologies. If I go flying away, somebody call my mother. So if an owner submits a records request and the association invoices them for the cost to compile the documents or provide the documents, and the owner fails to pay that invoice per the property code and per your open records policy, that amount can be put on the owner's account. But again, per 209.09, you cannot foreclose if the amounts owed to the association are solely those are fines or fees related to police. Okay, this is a statutory right per TUCA. Kyle says I froze. Can you see me all right, Kyle?
Yeah, we got you. Our internet just blipped for a second, Eric.
All right. My apologies, guys. We're having just terrible weather outside, so it may affect a little bit our connectivity. Hopefully not anymore. So for all condos, there's a statutory right of non-judicial foreclosure. A power sale is granted in the statute. However, it may not be used for pre-1994 condos if the governing documents require another process, such as judicial foreclosure. So for example, Chapter 82 condo, you have an absolute right to foreclose to non-judicial foreclosure, which means you don't have to file a lawsuit. You send notices and then post the property. The trustee for the association posts the property and then conducts a sale. A judicial foreclosure is where you file a lawsuit and get a judgment which awards a power sale or order for foreclosure in the judgment, along with all the other relief sought. Again, per TUCA, 82 associations have the right to non-judicially foreclose at any time. 81 may or may not. Again, it depends on what the declaration says for that Chapter 81 condominium. If it specifically says that you only can file a judicial to seek the collection and foreclose via judicial lawsuit, then that non-judicial power is trumped by what's in your declaration. Next slide, please, Kyle. All right, both HOAs and condominiums have a right of redemption. The right of redemption applies to all association foreclosure sales. For 209 associations, it's up to 180 days after the date that the notice of the right of redemption is mailed by the association. For condominium, it's up to 90 days after the date the foreclosure sale. So a little bit difference in the time period between a condo and a single family. There's both have very specific requirements as to who pays to what and to who. And there's also, at least for a mortgagee or a lender has a right to redeem a property on behalf of an owner in some situations. That time period is a little bit different also, but it does exist. So just be aware of that. Next slide, please, Kyle. All right, for 209 association, 209.063 sets forth the priority of payments. This is the application of payments. When you receive a payment from an owner, it must be applied in this order, unless you see that actually the second bullet point. If the owner is in default of a payment plan, then you don't have to follow this priority of payment schedule. So assuming an owner is not in default, if you receive a payment, it must first be applied to a delinquent assessment, if there is one, a current assessment, again, if there is one, any attorney's fees associated with assessments or any other charge that can provide the basis for foreclosure, other attorney's fees incurred by the association, fines assessed by the association, and then any other amounts owed to the association. But even if the owner is in default, and you don't have to follow this schedule, you still cannot put fines as a priority. Fines have to be at the bottom of the list, regardless of even if they are in default. Next slide, please, Kyle. So for condos, 82113 of the property code applies to assessments, and it says that assessments means your regular and special assessments, dues, fees, charges, interest, late fees, fines, collection costs, attorney's fees, or any other amounts owed to the association by the unit owner or levied against the unit by the association. So that's the term assessments for property code purposes for all condominiums. Again, this is one of those provisions in 82 that applies to Chapter 81. Gives you the definition of what an assessment means. Next slide, please, Kyle. So for a 209 association, assessment means a regular assessment, a special assessment, or any other amount of property is required to pay to an association under a declaratory instrument or the law. So that's your distinction between assessments for 209 versus condominiums. Next slide. Okay, so 209 requires that payment plans be offered to an owner in certain circumstances. So payment plans must be a minimum of 3 months. That's per 209.062 of the property code. Exemption for associations under 15 units. It's a different standard for those. Priority of payments must be tied to the payment plan. If an owner defaults, an association, as I mentioned earlier, is not required to following the priority of payment schedule in 209.063. And there's no such requirement for condominiums. Next slide, please, Kyle. All right, now we're going to get into Chapter 202. A lot of these new laws that came into effect September of 2021. And so all these wonderful new laws that are most likely going to see some revision or amendment, hopefully, at this legislative session. And for those that may not know, we're currently starting the new legislative session for this year. And so I do know that there are some efforts being made to specifically for the security measures to address some of the inconsistencies or ambiguities in the current laws as it's currently drafted. Side note, we will be putting out in our newsletters updates with regard to bills that have been proposed addressing basically any legislation that affects property owners associations. And so just giving you a heads up on that, keep an eye out for that. So 202.023 of the property code addresses security measures. And what it says is it prohibits an association from adopting or enforcing a covenant that prevents an owner from building or installing security measures, including security cameras, motion detectors, and perimeter fencing. A POA is not prohibited from banning installation of a security camera in a place other than an owner's private property or regulating the type of fencing that owner may install. This does not apply to a condominium or a master mixed-use POA in Texas. So that's literally what the statute says. As you can see there, and as you've probably experienced, there's a lot of wiggle room in that very brief law that was adopted last year. What does the type of fencing, for example, what does the type of fencing mean? Does it mean the height? Does it mean the materials of the fence? Does it mean, color? What does type of fencing mean? So hopefully we'll get more clarity after this legislative session on what, that provision will be revised to add more clarity, because right now we have more questions than answers the way it's currently drafted. Also, what does perimeter fencing mean? Does it mean the perimeter boundary of the lot? Does it mean the perimeter up to the building lines as shown on the plat? The conservative advice would mean the perimeter of the property boundaries of the lot itself, not necessarily the building lines. But I have heard people try to make the argument that it applies to the building lines or the setbacks. Again, hopefully all this will be addressed in this legislative session. Next slide, please, Kyle. Okay, so the following slides are applicable to all HOAs and all condominiums. So next slide. 20203, construction of covenants. A restrictive covenant shall be liberally construed to give effect to its purposes and intent. What does that mean in English? It means that if we have a restrictive covenant in your governing documents, it's going to be liberally construed to try to give it effect, not narrowly construed, liberally construed. Next slide, please, Kyle. 202.04, enforcement of restrictive covenants. An exercise of discretionary authority by a POA concerning a restrictive covenant is presumed reasonable. Okay, so that's very important. So if an association pursues an owner for a violation of a restrictive covenant, that action is going to be presumed reasonable unless the court determines by preponderance of the evidence that the action was arbitrary, capricious, or discriminatory. Basically, whimsical, freakish, discriminatory doesn't mean racial. It could, but it just means you're not treating everyone the same. So if you go after one owner for a fence that is allegedly not in compliance with the restrictions, neighbor has the same fence, but the association doesn't go after that person, that's where the term discriminatory comes into play. Next slide, please, Kyle. So 202.04, I mentioned civil damages earlier. This is where that is located in the property code. But first and foremost, an association may initiate, defend, or intervene in litigation or administrative proceeding affecting the enforcement of a restrictive covenant. So basically, that's what gives the association standing to pursue an owner for violation of the restrictions. As I mentioned earlier, 202.004C of the property code is titled civil damages. Those are basically statutory fines, and it says that a court may assess civil damages for the violation of restrictive covenant in the amount not to exceed $200 per day for each day that a violation exists. So when we file a deed restriction lawsuit against an owner, we typically seek the recovery of $3,000 in civil damages, which is $200 a day. Sorry, it sounds like the tornado's about to come through my window. My apologies. $200 a day. So if we file a lawsuit, we seek $3,000, which is 15 days at the maximum $200 per day. Admittedly, oftentimes we use that as a bargaining chip because that's civil damages. That's found money. That's not a hard cost to the association. So a lot of times, not every time, but a lot of times when trying to reach a resolution with the owner, we will say, look, you pay the association's attorney's fees and court costs and any interest, and you fix a violation. We will waive the civil damages that's kind of a bargaining chip to try to get compliance with the restrictions and also to get the hard costs actually paid. Next slide, please, Kyle. Okay, 202.06 is public records. A POA shall file all dedicatory instruments in the real property records of each county in which the property to which the dedicatory instruments relate is located. Very important, this next bullet point. A dedicatory instrument has no effect until the instrument is filed in accordance with this section. So a lot of times I'll have a client that they have rules or regs or whatever, or a board policy, a resolution it was properly adopted at a board meeting or whatever the required voting method was, but it was never recorded with the county. That document is not enforceable unless or until it gets recorded with the county in which the property is located. If your association is located, for example, in Harris and Montgomery County, that document needs to be recorded in Harris and Montgomery County real property records. But again, if you do not record your dedicatory instruments, they are not enforceable. If you try to enforce them against an owner and the owner is savvy enough to see that that document wasn't recorded, then that owner is going to win in an action asserted against them because that document must be recorded in order to be enforceable. Next slide, please, Kyle. All right, 202.018, display of religious items. It prohibits an association from restricting a property owner from displaying religious items. The size of allowable displays is no longer restricted. So this amends the prior law, which had some size limitations that the association can enforce. So now, basically, the way that the law is drafted, an owner, so long as it's a sincerely held religious belief, that's the language in the statute, an owner can put anything on their property, so long as these 5 bullet points below. It's not a threat to public health or safety. Doesn't have offensive language or graphics. Doesn't violate a law of some sort. Doesn't violate applicable setbacks or easements, and it's not attached to certain structures. So if one of those 5 things come into play, then it most likely can have it removed. But if it doesn't, somebody wants to put a 50-foot cross in their front yard, 50-foot pentagram in their front yard, and it's a sincerely held religious belief, can't do anything about it. That's the way the law is currently drafted. So again, hopefully this is one of those things that gets kind of clarified in this legislative session. Next slide, please, Kyle. Swimming pool fences. This is also addressed in 202.022. So I'm just going to read this because this is right out of the code. It prohibits an association from adopting or enforcing a provision in a governing document that prohibits or restricts an owner from installing a swimming pool enclosure that conforms to applicable state or local safety requirements. A POA may enforce a provision related to the appearance of the enclosure, including the regulation of colors. But, and this is in the statute, such regulation cannot prohibit a black swimming pool enclosure that consists of transparent mesh set in metal frames. That is specifically in the statute. Not really sure why that is, but it is. So again, the association has a right to regulate the appearance of the enclosure, including colors. But if the proposed swimming pool enclosure is, again, transparent mesh set in metal frames, black swimming pool enclosure, transparent mesh and metal frames, you can't do anything about it. Next slide, please, Kyle. Rain barrels prohibits an association from restricting an owner from having rain barrels and rainwater harvesting systems. Must be consistent with the color scheme of the owner's house, and there are some screening requirements that are permitted. Again, this is in 202.007 of the property code. So if you want to see what those requirements are, feel free to refer to that. Also, we hand out a lot of little books, property code books. Actually, I have 2 right here. So one is for condos, one is for single family 209 associations. If you have these, it's in there. You can look at it there. If you don't have that, there's online property code that's free. So you can go to that and check it there. I refer to that very frequently myself. As far as these books goes, we're out now because, again, this is from the last legislative session. We'll be putting out these books after the new legislative session is completed. So that'll be later this year. And so keep an eye out for those. Next slide, please, Kyle. Political. So the same requirements. So an association may not prohibit one or more. Yeah.
You want to start that one over? You froze right as you were beginning.
Okay, the political signs, Kyle?
Yeah.
Okay. Okay, so for political signs, this used to be in the property code. It is now in the elections code. Again, the same requirements. It just got switched from one code to another. So an association may not prohibit one or more signs advertising a political candidate or a ballot item for an election, but there is a limitation on the dates before and after the election or the vote. So X number of days before, X number of days after. You can limit the size, location, and number per candidate or per issue. You can limit the type of material, and there's other limitations as well. And then association may prohibit non-ground mounted signs. An HOA may remove a sign displayed in violation of restrictive covenant permitted by this section. But again, you have to have a political signs policy in order to do that. In order to to enforce this, you have to have that policy. It's very important. All right, next slide, please, Kyle. Flags and flagpoles. 202.012 of the property code, it prohibits an association from restricting an owner from having a freestanding flagpole or attached to the home. It's also permitted in the front yard as well. It says that an owner has an absolute right to display the U.S., state, or armed forces flags. Now, when you see U.S. or state, Texas, obviously for us, it's not any variation of Texas. It's the flag is specified in the code itself as to what can be displayed. The pole must be 20 feet or less if there is a flagpole, and there's some placement and noise requirements that are permitted. So you can regulate some of the the placement and or noise from a flagpole. Next slide, please. All right, xeriscaping, the old and the new, 202.07 of the property code. POAs may not prohibit solid waste composing of vegetation, including grass clippings, leaves, brush, etc. Installing rain barrels or rainwater harvesting systems. Implementing the efficient irrigation systems, including underground drip or drip systems. However, this is the change: using drought-resistant landscaping or water-conserving natural turf, not artificial turf, natural turf. So that is a way to do that. And again, if you don't have a policy in place and this is an issue that affects your community, I suggest that you contact your attorney as far as adopting a policy addressing these issues. I believe that's the last slide, Kyle, right? Oh, nope, one more. The POA may require that a xeriscaping plan for the installation of drought-resistant landscaping or water-conserving natural turf be submitted to the association for review and approval prior to installation. Next slide, Kyle. There we go. I was trying to get a little quick on you. All right, so that concludes the presentation. I figure we're going to have a lot of questions, so kind of rip through that presentation kind of quickly. The slide deck can be provided to you if you like. Kyle, contact Kyle Beam. He's the magical Wizard of Oz I keep talking to. He can provide that for you if you'd like. So Kyle, if we can go to the chat, I can't